I was eating cereal in my tiny apartment when the envelope arrived. A thick, cream-colored thing that looked far too serious for my liking. The sender? A law firm I didn't recognize. Inside was the will of my recently deceased uncle, Richard Lawson, a man I hadn't seen in years but remembered as gruff, rich, and fiercely private. I flipped through the pages, heart thudding harder with each line. Then I saw it. To my nephew, Jamie Lawson, I leave the Lawson Ranch, its assets, in the family trust. I nearly dropped my spoon. My uncle had left me everything, but the relief was short-lived. Tucked in the same envelope was a second letter, from a judge no less, indicating that the will was under review. Judge Clarence Morton, a man with a reputation for strict rulings and personal vendettas, had declared a legal ambiguity and was holding the estate in probate. I knew the name Morton. He and my uncle had a long-standing feud over property lines and water rights back in the 90s. That's when I realized this wasn't a legal process. It was a hijacking. I called the law firm only to be met with awkward silence and vague responses. "We're cooperating with the court," they kept saying. "This isn't the first time we've seen something like this." That's when the dread set in. I wasn't just fighting for a ranch. I was about to enter a courtroom cage match with a judge who had already decided I didn't deserve my inheritance. Over the next week, I tried to hire a lawyer, 4 to be exact. Each one declined. Some cited conflict of interest. Others whispered that no one wanted to go up against Morton in his own court. One even told me, "If Morton wants your inheritance, he'll get it." The system was stacked. So I did something stupid, something reckless, something that made my mother call me insane. I decided to represent myself. I spent nights combing through law books, Googling legal procedures, watching YouTube videos of amateur court cases. I turned my living room into a war room, pinning photos and documents to the wall like a conspiracy theorist. I even subscribed to an online course called Civil Court for Dummies, which ironically became my Bible. At first, I didn't understand half the words. Amicus curiae, ex parte, habeas corpus. It felt like Latin was designed to keep people like me out. But I didn't stop. I created a binder so thick it could stop a bullet. I learned that the will had already been notarized, witnessed, and filed, making it legally binding unless fraud or coercion could be proven. I found a 2006 court ruling that mirrored my case. Precedent was on my side. But none of that mattered if Morton chose to ignore it. My friends thought I'd lost it. "Just walk away," one said. "Sell the land, split it, whatever." But I couldn't. This wasn't about land anymore. This was about standing up to someone who believed power made them untouchable. I started digging into Morton's career, his rulings, his connections, his assets. I found a pattern. He frequently presided over cases where his own real estate interests stood to benefit. The ranch, I realized, sat adjacent to land owned by Morton's son-in-law. Coincidence? Hardly. I requested public records. I filed Freedom of Information Act requests. Every shred of paper I collected painted a picture. This judge wasn't just reviewing a will, he was preparing to steal a legacy. One morning I drove out to the ranch, just to see what I was fighting for. It was more beautiful than I remembered. Rolling hills, oak trees, a red barn with rusted hinges. It smelled like memories and hard work. A man in a sheriff's uniform met me at the gate and handed me a restraining order, issued by the court, to prevent unlawful occupancy during pending litigation. I wasn't allowed to step foot on my own inheritance. That night I sat on the hood of my car outside the property line, staring at the stars, wondering if I'd made a huge mistake. But then I remembered Uncle Richard's voice, deep and scratchy, telling me as a kid, "Lawson men don't run, we dig in." I filed my response with the court the next morning. It was messy, filled with handwritten notes and typos, but it was enough to force a hearing. When I showed up in court, people stared. I didn't wear a suit. I wore my uncle's old jacket, the one with the stitched RL on the inside. Judge Morton peered at me over his glasses, smirked, and said, "You'll be representing yourself?" I nodded. "This should be amusing," he muttered. And just like that, the war began. I didn't know how far I'd have to go, but I knew one thing. I was ready to fight like hell. The courtroom smelled like pine-scented disinfectant and old secrets. Every day I walked through those heavy oak doors, I felt like a trespasser in someone else's world, a world full of polished shoes, clipped syllables, and smug whispers. Judge Morton sat high above the rest of us like a vulture guarding its perch, gavel in hand and a scowl carved into his face like it had been chiseled there in stone. The first hearing began with him reading the concerns about the will's legitimacy, citing possible undue influence and lack of mental capacity on my uncle's part. It was pure theater. My uncle had been sharp as a tack until the day he died, and Morton knew it. He was laying a trap, and he wanted me to fall face first into it. But I had spent every night preparing for this. Every document in my binder was cross-referenced, highlighted, and annotated like scripture. "Mr. Lawson," Morton said during one hearing, "do you even know what a probate petition is?" I stood slowly. "Yes, Your Honor. It's the formal process of validating a will, which, according to state law, only becomes contestable with evidence of fraud, coercion, or mental incapacitation, none of which have been presented here." The courtroom went quiet. Morton's eyes narrowed. He didn't like that I'd done my homework. I could feel the hostility radiate off him, but I met it with the same stubborn calm my uncle once used when negotiating cattle prices. Week by week, the case slogged forward. Morton threw every procedural wrench he could think of into the gears. Last-minute reschedulings, dismissals of my motions on technical grounds, even denying my request to access my uncle's safe deposit box. He claimed I had insufficient standing, despite being named as the sole beneficiary. I countered every move, citing case law, legal articles, even quoting obscure probate precedents I found buried in the state's digital archives. I became a courtroom barnacle, annoying, immovable, and impossible to scrape off. The clerk, a tired-looking woman named Dana, started slipping me sympathetic glances. One day she whispered, "Keep going. Everyone sees what he's doing." That same afternoon, I made my boldest move yet. I subpoenaed Morton's son-in-law, a real estate developer named Byron Kemper. My research had revealed that Kemper had been quietly buying land adjacent to the Lawson Ranch for years. If he acquired the ranch, it would link his parcels into a massive development zone, worth tens of millions. The courtroom buzzed when I filed the subpoena. Morton looked like I'd punched him in the gut. He recused himself from that day's hearing, citing conflict of interest, but not before lambasting me in front of the court for malicious and inappropriate conduct. The new temporary judge, a no-nonsense woman named Justice Everett, seemed unimpressed by Morton's antics and allowed Kemper's deposition to proceed. That changed everything. Under oath, Kemper squirmed like a worm on a skillet. I asked about his land purchases, his emails with Morton, his interest in the Lawson property. He deflected. I presented a printed chain of text messages I'd obtained through a public records request. Messages showing Morton had given him advance notice of the will's filing and advised him to prepare for acquisition. Gasps echoed through the courtroom. Kemper turned red. My heart pounded so loudly I thought the mic would pick it up. Justice Everett asked to review the text and recessed court early. I knew I had struck a nerve, but I also knew this fight was far from over. That night I found my car tires slashed outside the courthouse. No note, no witnesses, just 4 puddles of rubber and spite. I didn't report it. I replaced the tires myself in the dark, greasy hands shaking as I tightened the last lug nut. Morton was sending a message, but so was I. I wasn't backing down. The next morning I filed an ethics complaint against him with the state's Judicial Conduct Board. I didn't expect it to succeed, but I wanted it on record. I wanted the world to know that this judge wasn't impartial. He was an architect of fraud hiding behind a robe. Then came the day Morton called for an emergency review of the will, claiming new evidence had surfaced. An alleged second will, conveniently naming a vague, historical preservation trust as the new heir to the estate. The trust had no website, no physical office, and no known members. I dug into its registration and found that it was incorporated 2 months prior by Morton's golf buddy. I filed a motion for fraud and demanded a full forensic analysis of both wills. The courtroom erupted into chaos. Morton tried to overrule me on the spot, but Justice Everett returned and halted the proceedings. She scheduled a formal evidentiary hearing and allowed me full access to the county's will registry and forensic document analysis. The week before the hearing, I worked out of a storage unit filled with legal pads, charts, and a growing collection of energy drink cans. I was exhausted, broke, and running on fumes, but I had enough evidence to bury Morton's little trust in paperwork. I discovered the alternate will used a typewriter model that hadn't been manufactured since 1989. My uncle's was destroyed in a barn fire in 1997. The ink didn't match anything in his house. The witnesses listed were both dead, and the signature, a near-perfect replication of his 2004 signature, down to the misplaced loop in his L, but done with modern pen ink. The hearing began under a packed gallery. News had gotten out. Reporters from the local paper showed up. So did a few law students and some folks from my uncle's town. I presented my evidence like a lawyer in a Netflix documentary, walking the court through the timeline, the forged documents, the fake trust. I ended with a printout of Kemper's property map with the Lawson Ranch drawn neatly in red, labeled Phase 4. The silence in the room was suffocating. Then Justice Everett looked down at her bench and said, "We'll reconvene in 3 days. I want to examine everything." Outside the courtroom, Morton brushed past me without a word. But the look in his eyes, it wasn't anger, it was fear. I realized then I was winning, not because I was the smartest guy in the room, but because I refused to be quiet, because I forced the truth out, one shred of evidence at a time. And for the first time since this whole mess began, I actually believed I could win. 3 days later, the courthouse felt different. There was a hum in the air, a quiet buzz of curiosity and anticipation. Word had spread beyond our small county. The local paper had printed a front-page story titled "Judge or Thief? Probate Battle Unveils Possible Corruption." It featured a photo of me walking out of court, binder under my arm, with the caption, "Nephew defends family legacy against judicial power." It was surreal. Strangers were now stopping me on the street, patting my shoulder, offering their support. "Give 'em hell," one man whispered as I passed. I wasn't just fighting for my inheritance anymore. I had somehow become the face of every regular person who ever got steamrolled by a broken system. Reporters camped outside the courthouse, their vans taking up all the street parking. Inside, the gallery filled quickly. Neighbors, journalists, even a few law professors I recognized from my late-night research videos. When Justice Everett entered, the room quieted like a switch had flipped. She acknowledged the heightened attention and made one thing clear. This court is not a spectacle. We will deal with facts, law, and nothing else. And yet there was no denying it now. This case had become more than legal wrangling. It was a referendum on judicial abuse. That day I presented forensic evidence from the ink used in the forged will. A certified document examiner testified that the ink belonged to a brand released only in 2018, long after my uncle's death. The fake trust was crumbling under scrutiny. My cross-examination of its supposed representative was almost too easy. The man had no knowledge of trust operations, no insight into Richard Lawson's affairs, and couldn't explain why their mailing address led to a rented P.O. box at a liquor store. When I asked him who paid for the trust's registration fees, he hesitated and glanced toward the back of the courtroom, where Morton usually sat before proceedings. I followed his gaze, then turned back to the judge. "Let the record show the witness looked toward Judge Morton's usual seat before responding," I said. Gasps again. The judge scribbled something on her notepad. The truth was no longer whispering, it was screaming. I also called Dana, the court clerk, as a witness. She had been compiling notes of her own, tracking Morton's irregular docket changes, the way he kept sealing documents without cause, the pressure he placed on staff. Her testimony didn't just bolster my claims, it painted a picture of a courtroom run like a personal kingdom. Morton, for once, had no comment. He was suspiciously absent, but his shadow loomed over everything. That afternoon, the Judicial Conduct Board issued an official statement confirming an ongoing investigation into Judge Morton for potential ethical violations relating to estate interference and misconduct. I printed that statement and taped it to my war binder. It wasn't a victory, not yet, but it was the first real blow that landed. My confidence grew, but so did the pressure. News vans now followed me home. My inbox was flooded with emails, some offering legal tips, others warning me to watch my back. A retired judge even sent a message titled, "They'll come for your character next. Be ready." And they did. The very next day, an anonymous article appeared online accusing me of financial mismanagement, unpaid debts, and estranged family members who didn't trust me. It was a smear campaign so lazy it listed my cousin Brian, who'd been dead for 5 years, as a source. But it rattled me. It showed me how far Morton and his allies were willing to go. I had to respond, but not with more accusations. I called a press conference instead, standing outside the courthouse with my binder in one hand and my uncle's jacket slung over my shoulder. "This fight is about more than land," I said into a dozen microphones. "It's about fairness, about not letting powerful people steal from the rest of us just because they wear a robe or sit behind a bench. My uncle trusted me with his legacy. I intend to defend it, fully, legally, and publicly." The applause surprised me, but what really floored me was the next question, from a reporter in a crisp blazer who asked, "Have you considered law school after this?" I laughed. "One battle at a time," I said. The media pressure started working in my favor. A nonprofit legal foundation reached out, offering advisory support. They couldn't represent me directly without taking over the case, but they sent briefs, legal templates, even arranged an independent analysis of the entire case file. Their help sharpened my arguments and gave me tools I hadn't even known I could use, like compelling phone records through a subpoena duces tecum, which I did. The calls revealed that Morton and Kemper had spoken over 20 times in the 2 weeks following my uncle's death, despite Morton's official claim of no contact. With the walls closing in, Morton made a desperate move. He requested that the entire case be transferred to another district, one where he had former clerks now sitting as judges. But this time, Justice Everett denied him. "This court will not reward strategic venue manipulation," she declared. For the first time, Morton was pinned. His motions were denied. His allies were silent. His throne was wobbling. I used the momentum to request a full audit of the Lawson Trust. My uncle's assets were extensive: cattle, real estate, patents, and mineral rights, and I wanted everything on record. The audit revealed a surprising twist. A large sum, over $500,000, had been transferred from the estate's business account to a shell corporation 6 months before Richard's death. The corporation registered under Kemper's wife's name. This discovery hit like a lightning bolt. It proved that the fraud wasn't just future planning. It had already started while my uncle was alive, possibly without his knowledge. I made this the centerpiece of my next court appearance. This wasn't about questioning the will, I told the court. This was about looting the house before the funeral ended. The gallery was silent. Justice Everett asked the court reporter to read back the last sentence. She looked at me with an expression I hadn't seen before, something between admiration and pity. "Mr. Lawson," she said, "you may have just turned this case from probate to criminal." The mood shifted the moment Justice Everett used the word criminal. It was as if the air had thickened, the gravity in the courtroom had doubled, and every eye locked on me with a new kind of weight. Up to that point, I'd been treated as a stubborn underdog, scrappy, overprepared, probably doomed but persistent. But now I was something else. I was the catalyst for a criminal investigation into a sitting judge, and no one knew where that might lead. The reporters outside smelled blood in the water. Legal observers began dissecting the case on late-night panels. "If proven, this could be the largest abuse of probate power in state history," one pundit said. I heard my name sandwiched between words like integrity, judicial reform, and explosive. And yet, I wasn't celebrating, because I knew Morton wouldn't go down without a scorched earth fight. The audit revelations cracked open a whole new corridor of suspicion. I filed a motion requesting forensic accounting on every major transaction from the Lawson Trust over the last 2 years. The motion was granted. What followed was a tsunami of documentation: bank statements, wire transfers, contracts, even receipts for consulting services that looked like money laundering dressed in khakis and clipboards. One company listed on a $70,000 invoice turned out to be registered to a storage unit, and its listed CEO, a man who had been dead since 2013. I presented this in court, my voice steady, though inside I felt like I was unraveling a haunted house built on greed. Justice Everett began calling private, closed-door sessions with senior investigators and auditors. That's when I knew the scope had expanded. I wasn't just fighting for my ranch anymore. I was cracking open a Pandora's box of legal corruption that spanned judges, lawyers, developers, and shell corporations. And with each new revelation, the faces in court grew longer, more cautious. Kemper stopped showing up. Morton filed a formal complaint against Justice Everett herself, claiming judicial bias. The complaint was thrown out in less than 48 hours, but it showed how desperate he was becoming. His allies began to vanish like rats leaving a sinking ship. And then, like clockwork, the attacks on me intensified. My bank account was flagged for unusual activity, locking me out for 3 days. My email was hacked. A fake Facebook post circulated showing doctored photos of me allegedly partying with stolen money. It was pathetic and obviously fake. I haven't been to a club since college, and the post misspelled my name as Jimmy. Still, it shook me. This wasn't just courtroom chess anymore. It was trench warfare. I started sleeping with a bat under my bed and a flash drive of evidence in my sock drawer. I had become my own security, legal team, and media handler. My life revolved around depositions, subpoenas, and guarding every bite of data I collected. But I kept pushing. I requested access to Morton's financial disclosures, citing the ongoing investigation and the possibility of personal enrichment through the fraudulent trust. It was a long shot, but the judge approved it under seal. What we found was damning. Morton had made several large property investments through LLCs managed by his niece. LLCs that received sudden cash infusions within days of suspicious estate transactions. A pattern emerged. Trusts that passed through his courtroom often ended with assets reallocated to shell entities tied to his family. Mine was just the latest in a long con. This wasn't personal revenge. This was professional embezzlement wrapped in legalese and powdered wigs. I stood in court and laid it all out. My timeline, the transactions, the emails, the text messages, the LLCs, the forged will, the golf course meetings, the phone calls, and the property maps. It took nearly 2 hours to get through my presentation, but when I finished, no one clapped. No one moved. It was like I had dropped a nuke in the middle of the courtroom. Justice Everett called for a 24-hour recess to process the scope of the new evidence and coordinate with criminal authorities. Translation: shit just got real. That evening, the courthouse was surrounded by news crews. I declined interviews. I didn't want to be famous. I wanted to be done. I called my mom for the first time in weeks, and she cried on the phone saying, "Your uncle would be so proud of you." I stood in the kitchen of my crummy apartment, staring at the fridge full of takeout boxes, and cried too. Not from sadness, from exhaustion, from release, from the feeling that after all this I might actually win, not just the case, but something bigger, something lasting. The next morning, U.S. Marshals escorted Morton out of his chambers. It wasn't a full arrest, yet, but he was being removed pending further investigation. That visual alone made headlines for days. Judge removed amid inheritance fraud scandal. My inbox was flooded again. This time the messages were from people in similar situations. Nieces, sons, caregivers, all who had felt bulldozed by the probate system. I started compiling their stories. I didn't know what I'd do with them, but I felt like I owed it to them to keep fighting. Meanwhile, Justice Everett appointed a new independent judge to preside over the remainder of the trial. Judge Renee Wu, a former federal prosecutor with a reputation for incorruptibility, took over. Her first act? She ordered a full federal inquiry into Morton's past rulings. Her second? She reopened my access to the Lawson Ranch and ordered a protective injunction preventing any sale, development, or transfer until the case was resolved. For the first time in months, I drove to the ranch without being turned away. I walked the fence line at sunset, boots crunching in the dust, my uncle's hat pulled low. I stood by the red barn and ran my hand over the weather-worn wood. I whispered, "We're almost there, old man. We're almost there." But I knew the road ahead was still long, because even though Morton was out, the damage he'd done remained. I would need to unwind fraudulent contracts, push for restitution, and rebuild trust in a system that had allowed this corruption to fester for years. And I wasn't naive. I knew there were more Mortons out there, more courtroom kings playing God with people's lives. I just happened to be the one who said no, who stayed, who fought. And now, with the public watching and the legal machine finally grinding in the right direction, I had one goal left: to finish what I started. I returned to the Lawson Ranch not as a visitor, but as its rightful heir, at least temporarily. The protective injunction signed by Judge Wu granted me legal access, and I wasted no time. I parked by the cattle gate, the same one where I'd been served a restraining order months ago, and this time I stepped out with keys in hand, not a court summons. I wasn't sure what I expected: a triumphant wave of peace, some kind of emotional catharsis. Instead, I found silence. The kind of silence that hangs in the air after trauma, not victory. Grass had grown tall and unkempt along the driveway. The barn doors creaked in the breeze, and several windows in the main house were cracked. Inside, the power had been turned off, and the air smelled like mildew and abandonment. The place looked like it had been forgotten, like someone wanted it that way. I knew immediately this was no accident. Whoever had been handling the estate during Morton's interference hadn't just stalled, they had sabotaged. Vital records were missing. The office was stripped of hard drives and filing cabinets. Photos of my uncle had been taken down. In the back room, his workshop, where he tinkered with everything from broken radios to antique watches, I found shattered glass on the floor. His old ledger book, the one he kept religiously since the 80s, was gone. Rage burned in my chest. This wasn't negligence. It was a cover-up. I spent the next several days cataloging the damage. I hired a locksmith, an electrician, and even brought in a friend who worked in digital forensics to scan any leftover devices. In an old safe hidden behind a shelf in the pantry, we found one glimmer of hope: a thumb drive labeled simply, "For Jamie." It was dusty and slightly warped, but still functional. I plugged it into a borrowed laptop, and a folder popped open. Personal notes. My uncle's voice crackled to life in a series of audio recordings. "If you're hearing this," he began in one, "then things went sideways." He detailed his growing suspicion that Morton was maneuvering behind the scenes to get his hands on the land. He mentioned conversations that didn't sit right, unexplained legal visits, even the sudden disappearance of his long-trusted estate attorney. "Don't let them take it, Jamie," he said in one file, his voice grave. "This land has history, family. It's not for sale." I cried alone in that house, listening to the voice of a man who'd prepared for this betrayal but never lived to see it unfold. It reignited the fire in me. This wasn't just about beating Morton in court anymore. It was about restoring what they tried to erase. The ranch had become a battleground, not just for land but for memory, legacy, and truth. The next week was a blur of inspections, cleanup, and recovery. I found several invoices for estate management services billed to shell corporations linked to Kemper. One invoice included an $18,000 charge for art removal and disposal, which explained the missing portraits and heirlooms. I reported it all to Judge Wu's appointed forensic team, who began preparing restitution reports and asset recovery motions. But I didn't wait for the system to work. I posted photos of the damage on social media with the caption, "This is what probate corruption looks like." The post went viral. Tens of thousands of shares. The local news ran a follow-up story: "Ranch plundered while court delayed inheritance." Public outrage swelled. Protesters showed up outside the courthouse with signs reading, "Justice for Lawson" and "Restore the Ranch." That pressure mattered. It kept the wheels of accountability turning. Judge Wu authorized a full civil investigation into Morton's entire probate docket, and several other families came forward, each with horror stories that sounded eerily similar. One widow had lost her home. Another man's family trust had been drained under emergency conservatorship. Morton wasn't just a bad judge. He was the epicenter of a quiet plague infecting the probate system, and I had unintentionally become its antidote. Meanwhile, my uncle's voice in those recordings became my compass. In one file, he described the original boundaries of the ranch before a disputed land grab. That led me to an old filing cabinet in the tool shed, overlooked during the looting, where I discovered survey maps and water rights documentation. These were critical. They proved the ranch's access to a key underground aquifer that ran beneath Kemper's adjoining developments. Suddenly, I understood the full picture. This wasn't about family feuds or old vendettas. This was a resource war disguised as probate. Armed with the maps, I returned to court with a motion to void any agreements made on behalf of the estate since my uncle's death. Morton's cronies had signed off on several development exploration rights that gave Kemper's companies preliminary access to conduct geological surveys. If they'd struck water, or worse, claimed it legally, I could have lost everything without even knowing it. Judge Wu reviewed the documents and declared the agreements null and void. Fraudulent representation of authority, she said flatly. This court will not recognize theft in disguise. It was a massive win, and yet each victory came with emotional weight. Every document I recovered, every photo I rehung in the house, every field I walked reminded me of what could have been lost. I installed new locks, reconnected utilities, and began a restoration project. Volunteers from the local community showed up, some with tools, others with food, all with stories. One elderly man told me he used to work with my uncle repairing tractors. He wouldn't have wanted this place quiet, he said. He'd want it alive. That stuck with me. I started rebuilding, not just fences and barns, but relationships. I reached out to neighbors, local ranchers, even schools. I hosted a small community day, invited families to walk the land and hear the history. We planted a new oak tree near the old corral, and I hung a plaque beside it for Richard Lawson, a man they tried to erase, a legacy we refused to forget. But my fight wasn't finished. Restoring the ranch was personal. Restoring the truth was public. I began working with the legal nonprofit that had once supported me from afar. Together, we drafted a policy proposal for statewide probate oversight reform. We called it the Lawson Act. It aimed to require third-party audits in all probate cases involving estate transfers over $1 million and to ban judges from ruling on estates that share financial proximity to their family members. It was bold, ambitious, and probably a long shot, but so was everything else I'd done. Judge Wu scheduled the final probate ruling for the following month. The courtroom would be packed again. News outlets had dubbed it the verdict that shook probate. And while I knew what the law said, what the evidence proved, and what justice demanded, a part of me still held my breath. Because when you spend this much time fighting the system, you start to forget what fairness looks like. Still, I prepared. I polished every fact, sharpened every timeline, and rebuilt my war binder with fresh tabs, notes, and exhibits. Not because I thought I'd lose, but because I needed to finish strong. For my uncle, for the ranch, for every person who'd sent me a message saying, I thought I was alone. Courtroom 4A was full by 7:45 a.m. The final probate hearing was scheduled for 9, but people began arriving before dawn, some wrapped in blankets, others holding cardboard coffee cups and hand-drawn signs that read, Justice for Lawson and Clean Courts Now. I slipped through the side entrance with my war binder under one arm and my uncle's jacket over my shoulders, creased at the elbows, weathered like everything else in my life by now. This wasn't just a courtroom hearing anymore. It was the climax of a legal saga that had spiraled from a private inheritance to a public reckoning. The cameras were rolling, the gallery was humming, and the nation was watching. I took my seat at the petitioner's table and tried to steady my breathing. No lawyer beside me, just me, my facts, and the weight of everyone who'd ever been screwed over by someone in a robe. Judge Renee Wu entered with the same calm intensity she'd carried since her appointment. She didn't wear arrogance like Morton had. She wore certainty. Her reputation for incorruptibility had brought a measure of peace to the circus this case had become. She addressed the courtroom briskly. This court will now render a final decision on the matter of the Lawson estate, including rightful ownership, fraud restitution, and judicial misconduct findings. The words felt heavier than stone. This was it. The hearing began with a recap of evidence, presented not by me this time, but by the court's independent audit counsel. They walked through the key findings: the original authenticated will signed and notarized by Richard Lawson, the fabricated alternate will connected to Morton's golfing associate, the suspicious money transfers, the forged signatures, and the undeclared relationships between Morton, Kemper, and a web of shell companies. Each point hit like a hammer. Every name, every date, every dollar moved, painted the full portrait of what we'd all suspected. This wasn't negligence. This was organized theft. Then it was my turn. I stood up, cleared my throat, and gave the last statement I hoped I'd ever need to make in a courtroom. This wasn't about money, I said. It was about dignity, about a man who worked his whole life to build something meaningful, only to have it stripped from him in death by a system he trusted. I held up my uncle's ledger, recovered at last from an old contractor who had been instructed to clean out clutter by one of Kemper's people. This is what they tried to erase, I said. Every page, every entry is proof that Richard Lawson didn't just own a ranch, he lived it, and he wanted that life passed on, not parceled out. I ended my statement with something my uncle once told me, captured on one of his voice recordings. Legacy isn't land. It's what you leave behind when you're no longer here to defend it. I sat down to silence. No applause, no outbursts, just a thick, reverent stillness. Judge Wu reviewed her notes, adjusted her glasses, and then looked me dead in the eye. This court finds the original 2023 will of Richard Lawson to be valid and enforceable, she said. My heart thumped so loud I thought the microphone might pick it up. The Lawson Ranch and all associated assets are hereby returned to the sole legal heir, Jamie Lawson. I closed my eyes for a second, just to feel the moment. I had won. It was over. But she wasn't done. Furthermore, she continued, this court refers Judge Clarence Morton to the State Judicial Review Board for permanent disbarment and criminal prosecution under statutes of probate fraud and abuse of office. Gasps erupted in the courtroom. Flashbulbs exploded. People were crying. I looked down at my binder, pages worn, bent, highlighted into oblivion, and realized I'd just done what almost no one thought possible. I beat a judge in his own arena, with the system stacked against me. But the most surprising part came next. This court also recommends referral of this case to the state legislature's Ethics and Oversight Committee for consideration of systemic probate reform. Wu added, the issues raised herein merit wider examination. That line lit up the internet. Within hours, hashtags like probate reform and harsh Lawson verdict were trending nationally. Pundits on both sides of the political spectrum agreed on one thing. What had happened to me could have happened to anyone, and the Lawson case had finally pulled back the curtain. After court adjourned, I walked out the same door I'd come through all those months ago, only this time, reporters swarmed me not as a curiosity, but as a symbol. How does it feel? Someone shouted. Will you keep the ranch? Do you plan to sue for damages? Are you going into politics? I didn't have good answers to any of those. All I could say was, I'm going home, to clean up, to rebuild. That's all I ever wanted. Back at the ranch, the sunset looked different. Not just because the air was clearer or the fence was repaired, but because the burden was finally gone. I sat on the porch with a bottle of water and my uncle's old shotgun leaning by the door. Not for security, just tradition. I thought about everything I'd learned, how truth can be buried under paperwork, how justice is slow but not silent, how power corrupts most easily when no one dares to challenge it. Over the following days, I was inundated with letters, actual handwritten letters from people around the country. One came from an 89-year-old woman in Georgia who'd lost her home to probate fraud and said my story gave her just enough strength to fight back. Another came from a young law student in Seattle who said he was switching his concentration to probate law, because this is where the real battles are. I pinned those letters on the wall of my uncle's office, next to his old blueprints and family photos. That wall became my new trophy case. But fame is a double-edged sword. Offers came in too. Book deals, podcast interviews, even a dramatized miniseries pitch from a major streaming platform. I turned most of them down, not because I wasn't flattered, but because I didn't want to turn my uncle's struggle into entertainment. He wasn't a character. He was a man who deserved peace in death, not syndication. The only deal I entertained was from the legal nonprofit I'd worked with. They wanted me to help build a national awareness campaign for probate reform. That I agreed to. If one more person could keep their land, their home, their legacy because I stood up, then all the months of sleepless nights, all the shredded nerves, all the media chaos would be worth it. The day the state announced the formation of the Lawson Task Force on Judicial Ethics, I drove out to the edge of the property line, right to the tree we planted during the community day, and carved my uncle's initials into its trunk. Not because he needed the reminder, but because I did. To never forget what it took, to never forget what it cost, and to never ever let them do it again. Victory, it turned out, wasn't the end. It was a new beginning, one just as chaotic, demanding, and morally heavy as the fight that led to it. Once the gavel fell and the headlines slowed, the aftershocks of the Lawson case began rolling in like a tide that refused to stop at the shore. The first tremor hit just 2 days after the verdict, a subpoena issued to Morton by the state attorney general's office. What began as a referral for disbarment morphed quickly into a criminal indictment. Charges included conspiracy to commit fraud, tampering with court documents, and unlawful enrichment. Morton was arrested at his home. The mugshot, once unthinkable, ran on every local front page. The man who sat on the bench like a god was now an accused felon in a zip-up sweater, staring into a camera with hollow eyes. But Morton wasn't the only domino. His son-in-law, Byron Kemper, was charged as well, along with 2 estate lawyers who had quietly facilitated asset transfers through Morton's courtroom over the years. A total of 8 people were eventually indicted, with rumors of more names pending investigation. It wasn't just a scandal, it was a systemic collapse, a rot finally pulled from the floorboards of our state's legal system. I watched in disbelief as court calendars were cleared, old cases reopened, and victims recontacted for testimony. Some of them had emailed me months ago, thinking their stories would die in silence. Now they were getting justice, real justice. The ripple effects reached as far as the legislature. The Lawson Act, our probate reform proposal, was fast-tracked for debate in the state assembly. What began as a PDF on my hard drive was now a legislative packet sitting on the desk of people who could actually change the law. I was invited to testify. I sat there in a worn blazer, hands sweaty, binder in lap, and told the story again. This time not for a judge, not for a verdict, but for policy. If my uncle had died with less money, I told the room, none of this would have happened. It wasn't about fairness. It was about who could be looted quietly. The committee chair nodded gravely. "We owe you thanks," he said, "but we owe the people more." Meanwhile, back at the ranch, I was slowly putting things right. I'd used part of the trust to hire historical restorers to recover what had been damaged. My uncle's workshop, once ransacked and hollow, was now restored. Tools rehung, blueprints reframed, even his old ham radio reconnected. I'd found a retired carpenter who used to work with him, and together we rebuilt the porch using salvaged wood from the barn's damaged panels. Every nail felt like a stitch closing a wound. The town's support never wavered. People brought food, volunteers helped paint fences, and one local high school even sent students on weekends for community service credit. They cleaned, sorted, archived. One teenager, curious and bright, found a hidden drawer in my uncle's desk filled with old photos and letters, including correspondence between Richard and the town's founders. Letters full of dry wit, plans for irrigation projects, and debates over cattle breeds. These letters were a goldmine. I donated copies to the local museum, which then named a section after him, the Lawson Legacy Exhibit. But the attention also came with a darker undercurrent. A few Morton loyalists, people who had benefited from his court rulings, started whisper campaigns. They called me opportunistic, a media hound, a kid who got lucky. I ignored them at first, but when a blog post accused me of milking public sympathy and claimed my uncle's will had been doctored to begin with, I decided to fight back. I filed a defamation suit, not because I needed the money, but because letting it slide would dishonor everything I'd built. We settled out of court. They issued a public retraction. Sometimes the only way to clean the mud is to wade through it with a hose in both hands. And then came the letters from lawyers. So many lawyers. Offers to partner, to write, to advise. One firm wanted me to consult on a nationwide audit of rural probate cases. Another wanted to make me the face of a new watchdog foundation. I took my time. I didn't want to be another name on a press release. I wanted meaning, substance. Eventually, I partnered with that same nonprofit that had helped me early on. We started a program called Heirs Not Forgotten, providing resources and legal guidance for people facing suspicious probate proceedings. Our first case was a widow in Nevada. Her late husband's estate was caught in legal purgatory due to a mysteriously lost will. We helped her find archived copies, matched them with a witness's affidavit, and she reclaimed her home within 3 weeks. I started writing again, not for the court, but for the public. Op-eds, essays, blog posts. My most read piece was titled, "How I Beat a Judge with a Binder and a Promise," which ended up being assigned in at least 2 law school classes. Law students began emailing me for interview quotes. One professor asked if I'd guest lecture. I did. I walked into that classroom in boots and denim, stood in front of a projector screen, and told 23 future attorneys, "The law is only fair if someone makes it be. Don't forget that." There were nights when the silence returned, like a low fog. Nights where I missed the adrenaline, the purpose, even the fear. I'd walk the fence line with a flashlight, not because I expected trouble, but because routine kept me grounded. I'd listen to my uncle's recordings when the wind howled. I'd hear his laugh, that gravelly cough, the way he always said hell's bells when surprised. He was still there, in the soil, in the rafters, in every stubborn decision I made with my head held high. Justice had come, but accountability had just begun. I knew there were other Mortons, in other courtrooms, wearing other robes. I knew this fight would never really end, but I was okay with that now, because I wasn't just a guy who inherited a ranch. I was a man who inherited a cause, and I planned to defend it the same way I defended that land, with everything I had. A full year passed from the day I first received that will in the mail to the day I stood beneath the finished Lawson legacy exhibit at the town's historical museum. It was a modest display, nothing flashy, but every item inside told a story. My uncle's favorite boots, a pair of broken-rimmed reading glasses, old photographs of him standing beside tractors, and the voice recorder that helped bring justice to light. Visitors trickled in, nodding quietly at the captions, reading about the scandal, the verdict, the reforms that followed. Kids pointed at a map of the ranch where I'd marked trails, fences, and the creek line my uncle always said belonged to the bones of the land. And in a glass case at the center sat the original, validated will, yellowed at the edges, signed in strong cursive, framed like a Declaration of Independence. But that wasn't the end. That was just the monument. The real legacy, the future, was out on the land itself. The Lawson Ranch, reborn and bustling, was no longer just a place for cattle and sunsets. I'd converted one of the barns into a small legal education center. Nothing fancy, just long tables, projectors, and a wall full of pinned-up case studies. We hosted free workshops for locals and farmers, taught them how to read contracts, how to file proper estate plans, how to smell the stench of legal manipulation before it could fester. I brought in guest speakers, retired judges, whistleblower attorneys, probate watchdogs. People came. People listened. One woman drove 4 hours just to thank me. She said her father had lost his vineyard in a probate scheme 10 years ago. She handed me the deed and said, "It should have stayed in the family. It didn't, but you helped me understand why." The Lawson Act passed in the legislature 3 months after the final ruling. It included mandatory transparency audits for estates over $1 million, a rotating panel of independent probate auditors, and a ban on judges presiding over estates that shared any financial overlap with their relatives or business partners. The governor signed it with 3 pens, one of which he mailed to me with a note that read, "Thank you for shaking the tree." That pen now hangs in my office right above the ledger I recovered from my uncle's contractor. A physical reminder that even the biggest systems can be shifted when someone digs in. But as the world moved forward, so did I. There were still nights where I'd wake up from dreams that felt too real. Standing in Morton's courtroom, forgetting my notes, watching the ranch being auctioned off to men in suits with no names. Trauma doesn't vanish. It coils and waits. But I learned how to manage it. I turned my war binder into a book, part memoir, part legal guide. It was published under the title, The Dirt They Couldn't Bury, A Fight for Justice from the Ground Up. It sold well enough, but more importantly, it became required reading in several law clinics across the country. I visited one class in New York, and when I walked in, a student raised his hand and said, "I came to law school because of your story." I didn't know what to say. I just nodded. Life settled into a rhythm again, slower than before, but fuller. I started running the ranch the way my uncle taught me: early mornings, long walks with the dogs, evening checks on the water lines. I hired two hands, both veterans of bad probate experiences themselves, and we worked not just with cattle, but with purpose. The ranch became a sanctuary, not just for me, but for people who needed space to breathe again. Sometimes I hosted families in the guest house, those going through legal battles of their own, too burned out by the city, too scared to be alone. We didn't talk much about court. We just worked, cooked, watched the stars. Healing, I realized, is silent, but shared. The day I finally sat down and read my uncle's full handwritten journal, cover to cover, I cried harder than I had at the verdict. He wasn't just worried about the land. He was worried about me. "If the world comes for this place," he'd written, "I hope Jamie doesn't just fight. I hope he learns why it matters. The land is one thing, but the fight makes you a Lawson." I underlined that part. I think I'll frame it. In time, the public moved on. Other scandals came. Other headlines took their place. But the echoes of the Lawson case lived on. A journalist reached out for a documentary. I agreed on one condition: that it not be about revenge, that it tell the full story of corruption, yes, but also of redemption, of how community, evidence, and stubborn truth won over fear. It premiered on a small platform but exploded online. The Ranch Verdict, they called it, and I watched it once, just once, surrounded by a few friends and a bottle of scotch older than I was. When it ended, no one clapped. We just sat there in the quiet, letting the past rest for a minute. As for Morton, he was convicted on multiple counts. He lost his pension, his license, and his freedom. Last I heard, he was appealing from a federal facility out of state. His son-in-law flipped early and took a plea deal. Most of the stolen funds were traced and returned to affected families, including a couple I'd never met who'd lost a nursery business in the early 2000s because of one of Morton's rulings. I received a letter from them with a photo of the rebuilt greenhouse. "Your fight brought our soil back," they wrote. "There are still days when I miss who I was before all this. Just a guy trying to find his footing, eating cereal in a cluttered apartment. But now I know who I became. Not just the man who stood up to a judge, but the man who stayed standing long after the gavel fell. And the ranch, it stands too, rooted,